the Republic of Rwanda, and I'm going to be the moderator of this afternoon session. First of all, I thank the organizers for choosing me to be a moderator of this session, which is going to discuss the repatriation of proceeds of crimes. I take this opportunity again to thank the Office of DPP Kenya for the good job that they have done in organizing this African Prosecutors Association, especially those working in the background. I know how they suffer a lot in organizing this kind of session. Financial crimes such as corruption, fraud, and embezzlement of funds generate significant profits, often at the expense of the public budget. These proceeds of crime are usually hidden outside of the country where the crime was originally committed and laundered through complex financial and commercial transactions, often spanning across numerous jurisdictions. This session is going to explore how government can do better to recover cross-border proceeds of crime. We do have a presenter and discussant. Our presenter, Honorable Satyajit Borel, is a member of the Senate of the International Association of Prosecutors. Honorable Satyajit Borel was the DPP for Mauritius from February 2009 until 31st December 2022. So he has been a DPP for 13 years. You can imagine how experienced he is. And now he serves as the chairman for the Temple Group, Mauritius, which is an institution that specializes in anti-money laundering and countering of terrorism financing. We do have 3 discussants. Let me start with Mohamed Khalaf. Mohamed Khalaf is the head of International Division in Prosecutor General's Office in Egypt since 1995. We do have the DPP Zambia. Let me start with congratulating him because he's a new DPP of Zambia since December last year. Thank you, Gilbert. Before being appointed as a DPP Zambia, he was the Director General of Anti-Corruption Commission in Zambia. Our other discussant, Lawrence Wasden, who is the Attorney General IDA, has an experience, and I would like to request Marcus Green to tell us about the Attorney General. Is Marcus around? Okay, thank you.
Good afternoon. Now, wait a minute. I know it's after lunch and after the president, but good afternoon. That's better. So I recognize and give honor to the Excellency, the President of Ghana, Mr. Ruto, in absentia, and all other protocols observed. My name is Marcus Green. I sit on the board of the Attorney General Alliance, and I help lead the Attorney General Alliance Africa program. And so I don't want to take up too much time, but I do want to tell a little bit of a story. So many of you know what AGA does, right? The Attorney General Alliance, we do training across the continent on issues related to transnational crimes, prosecutors, judges, lawyers, investigators, and we do that training in 9 different countries. And since about 7 years ago, when we started, we've done close to 25,000 workshops and seminars across the continent. But what you don't know is that in order for that organization or the program to exist, it had to be approved by the overall board of the Attorney General Alliance. So what happens is the Attorney General Alliance is an organization that's been around for 30 years. There's a program up for consideration called the Attorney General Alliance Africa. This board, which is made up of attorneys generals throughout the country, the US, has to approve. And so the executive director presents this to the board, and there is not agreement, right? It wasn't looking good for the start of the program. You had some folks questioning whether or not we should be doing work in Africa, why are we spending resources in Africa? And there was one man, Attorney General, who stood up and said, if we're going to deal with transnational crimes, if we're serious about the rule of law, then we have to include Africa. And that man is the immediate past president, Attorney General Lawrence Wasden. So please, a round of applause. And General Wasden understands and embodies who we are at AGA, right? He understands that the connectivity of transnational crimes and the benefit of law enforcement being connected to each other. He understands that if the criminals are organized, so must be the justice system. We always talk about organized crime, but we need to talk about organized justice as the antidote for organized crime. He understands that breaking up a human trafficking ring in Nigeria can impact a young girl in New Jersey. He understands dealing with cybercrime issues out of Memphis can impact whether or not bridges are built in Malawi. This connectivity is who we are at AGA and what we do. And so we are proud to be one of the sponsors here. We are proud that General Wasden and his lovely wife, Tracy, could join us on this occasion. And by the way, 32 hours to get here. That's how long it took. And so we really, really do value his contribution to AGA Africa. We value the fact that he stood up for Africa. Sometimes, obviously he doesn't look African, but he is us, and he stood up for us and continues to stand up for us. So I wanted to honor him and to recognize him on this day. He's an individual that has spent 20 years standing up and fighting for the people of Idaho. And I said he was the immediate past Attorney General. He's no longer Attorney General for one simple reason. He refused to give in to the extremists of his party. He insisted on following the rule of law and insisted on doing things with fairness and integrity. And so we really, really, really do appreciate him. So if you want to understand AGA Africa and what we're about, take the time to talk to General Wasden. If you want to embrace AGA and the values that we have, embrace AGA Wasden, because he is AGA Africa. Thank you very, very much.
Thank you very much, Marcus, and we're going to learn from his experience, as we're going to learn from the experience of the presenter and other discussants. So our first presenter is going to highlight laws, regional and international instruments that can be utilized to recover proceeds of crime. As we started a bit late, we're going to compensate with the time that is going to be allocated to the presenter and the discussant, and we're going to try to respect the time. So, Honorable Borrell, the floor is yours.
Good afternoon, dear colleagues. I must say it's very heartwarming to see so many of my colleagues after a lapse of time. So courtesy demands that I say a big thank you to the Office of the DPP in Kenya for the very warm hospitality and for the very competent staff and the way we have been welcomed. So thank you very much, DPP Nordin, Haji Nordin, thank you. The topic we will be discussing for this session, repatriation of proceeds of crime, is very relevant for our part of the world. And it is a very complex one. There may not be any one-size-fits-all solution. And I can enumerate just now one good reason, because different jurisdictions have different legal cultures. And it is important that I'm not going to note that I have no ambition to say that I will be here to provide you with concrete answers, because there are none in my opinion. No two cases are the same. But I think it would be important to highlight the importance of the legal and institutional framework that must exist prior to even contemplating any action for the repatriation of crime. And the second thing is that the global community must be able to speak with the same language. It is very easier said than done. And this harmonization of what constitutes crime must apply across jurisdiction. So, because it's a very simple logic. If something is a crime in my country and not criminal in yours, and the money has landed in your country, there will be a clash of objectives. So there are different issues, different problems, but what is important before you even consider the next step for cooperation, you must have in place the institutional and legal framework. That was my point. Can I add some slides? Do we have the slides on? And I don't have a cue also. Now, according to some of the statistics available, the World Bank, for instance, the cross-border flow of proceeds from criminal activities, which include a series of global crimes like drug trafficking, bribery, corruption, tax evasion, is estimated between $1 trillion to $1.6 trillion. So it's a huge amount we are talking about. And out of this amount, approximately $40 to $60 billion originates in bribes to high public officials. and a large chunk of that covers the countries in Africa. Now, given the volume of what we are confronted with, given the involvement of multiple jurisdictions, given the complicity of financial institutions, both in our jurisdictions and outside, in foreign jurisdictions, especially Western financial institutions, given the fact that money can be disguised in a complex web of trust and in the name of third parties, given the fact that the beneficial owners of that money may not be difficult to detect because the money is placed in financial intermediaries or in the name of immediate relatives. Therefore, there's only one irresistible conclusion. It is that no single country or agency can pretend alone to succeed to confront the threats and proliferation that crimes across borders represent. Can anyone help me with the IT, yeah. Can you move on, next one? Yeah. So this is the way I propose to address my presentation. The first will be the introduction, which I have just done. And then we will be talking of some of the infamous cases, followed by the avenues of corruption, of cooperation, not corruption, the avenues of cooperation open to us, asset recovery, and I will end by saying that unexplained wealth orders should be the answer to some or to the myriads of procedural obstacles that investigators and prosecutors are faced with. I will develop the point on unexplained wealth orders when I conclude. So, next slide, please. Right. So that the measures, no, come on, slide before, the measures that need to be in place for cooperation between jurisdictions through exchange of intelligence, through mutual legal assistance treaties, extradition, and often the sharing of confiscated assets. So these are some of the objectives that should be contemplated in any country for the purpose of repatriation of proceeds of crime. Now, the first thing is to be part of this international convention, the multilateral treaties, because why do you want to be part of this? And if you have not, although I understand, there's no doubt that most of the countries here have been signatory members of UN Convention Against Corruption, UN Convention Against Transnational Organized Crime, because the simple reason, because we want to harmonize the legal disparity, the legal language, the legal regime. That's why we have to adhere to legal multilateral treaties and then proceed to make sure that these treaties become part and parcel of our domestic legislation. So these are it must be a two-pronged. First, the creation of the institutions, which in most countries already have the central authority, the legal process, a fast-track legal process, but then it is important because of the complexity of what we are faced with to have financial investigators, financial ex-auditors, people who can understand the meanderings of the international financial system. It's easier said than done, but you have to have within your country forensic specialists, how to follow the crime, the trail of the money. You have to be able to meet with your counterparts, to be able to discuss and give them the relevant information so that they can also do the necessary investigation in their own jurisdiction. But then, because if you don't have, you are not able to prepare a case, listing down the offenses, explaining what are the evidence, what are the basis for you to be reasonably suspecting alleged transfer of proceeds of crime, then the requested country, the country whereby you're making that request, may not respond because of the incidents, negative incidents or the constraints of its own domestic legislation. I would like for you to consider some of what I have termed as infamous cases. You will, of course, these are in the public domain. If it concerns your country, my apologies, it's all the fact that these are now in the public domain. You will see the case of a former Nigerian president, which is alleged to have where 273 million US dollars was acquired by the former president and his family from Switzerland, and the country involved was Nigeria. But then it was suspected that much more than this was transferred. But there was little of what this was a very meager sum, what has been returned. The second case also, if I may, that in April 2012, there was one governor who was sentenced to 13 years imprisonment at the Southern Crown Court after admitting conspiracy to defraud an amount of about 50 million pounds from the state which he was responsible. And the money was laundered through a number of offshore companies. All I'm saying is that I got this from the public domain. Now, of course, the amount stolen was something more. It was about $250 to $300 million. And the judge finally said that, well, what is being recovered is a meager sum compared to what is found. There's the other case of a former president of Zambia, my apologies to my colleagues here, where about $1 million was paid to his tailor in another jurisdiction. Well, it was clearly suspected that the money was being laundered. The investigation, they also, in the case of there's also the US Senate report whereby a number of officials from the Western African country where they make the contrast of people being in poverty while high official, this particular one, had purchased dozens of exotic automobiles, had bought 30 designer suits in a Paris-based shopping spree, and in a single 2-day period, and of course had made payments for $80,000 to Gucci and $51,000 to Dolce & Gabbana. So we are here concerned with this, the way people have sort of served themselves to public money, to taxpayers' money. And this is what we are about to look into. Now, the common thread about all this money, it's not only in Africa. I've taken some African cases because we are in the African Prosecutors Association. You know also cases in Malaysia, also in Mauritius. We are investigating in a case of unexplained wealth order. So it's some of the examples were for the consumption of this audience. Now, the common thread, and that's very important, the common thread is the complicity of the Western financial institutions in the grand scheme of corruption. Now, I mean, you would know that very recently, let me finish this, so without the complicity and the assistance of the global banking sector, a corrupt politician's essential laundering operation cannot be achieved. There must be another bank willing to receive that money, or another offshore company willing to put that in different jurisdiction to disguise the source of that stolen money. Now, you would know that last year, so sometimes they would take legitimate source, they would mix it with illegitimate source just to ensure that you cannot grab back the money, because they would explain how do you distinguish legitimacy, illegitimacy, and so on. But this should not be an issue anymore with some of the developments that have taken place. Now, you would know that August last year, the very famous investment bank, Goldman Sachs, was in complicity with the former Malaysian Prime Minister, Najib Razak, and concerning a scandal of one Malaysia Development Berhad scandal, which involved something like $4.5 billion of public money. And of course, to the credit of the Malaysian authorities and jurisdiction, action has been taken. The Prime Minister was prosecuted, he's now in jail. And of course, the cash was funneled through shell companies around the world and frittered away on yachts, diamonds, and the investigation have involved America, Luxembourg, Malaysia itself, Singapore, Switzerland, and the United Arab Emirates. So the porous, all these frontiers are porous when it comes to receive money. You know, it's a bit like all of a sudden the money from Russia, which was oiling well the financial system of London, has become all of a sudden, you know, dirty money. But all this time it was good. They were happily, they were buying football teams, they were putting in all the sectors of finance in London, and then for political reasons all turned dark money. So that the Financial Action Task Force report on laundering of proceeds of corruption gives some of the reasons that, of course, the advantages of once you've stolen the money, you want to hide it somewhere where it's beyond the reach of the domestic investigating team. And some of them which I have listed here on the slide, the ease which corporate vehicles can be created and dissolved in some jurisdictions, the fact that a vehicle can be created as part of a series of multi-jurisdictional structures in which a corporation in one jurisdiction is owned by one or more other corporation or trusts in other jurisdictions, the use of specialized intermediaries and professionals to conceal the ownership of that money. Even these professionals come forward to do that. Now, the use of vehicles whose only special purpose vehicles, famously known as the SPVs, that are totally opaque, no notion of accountability, no auditing, nothing. So it is in the dark corners of the whole financial process. What happened, these are used to disguise the beneficial owner of the assets. So the complete screen as regards. Now, FATF report cites Pinochet, the former Chilean president, in setting up corporate vehicles in order to both hide his assets and shield them from the reach of asset freezing and confiscation. So Pinochet was able to set up offshore shell corporations in trust and had filed in different countries in Europe, and of course the Spanish magistrate had filed a detailed indictment against Pinochet for crimes against humanity and issued worldwide freezing orders. Now, there was one bank called the Riggs Bank, it must be a US bank, so where the whole thing of the know your customer, if you go and open a bank account, I assure you, you will come out of the bank sweating, because the number of questions they would want you to probe and ask you. But here you are, Mr. Pinochet was able to dissipate billions of dollars with the complicity of the bank. So I want perhaps to get our brain a bit to tick, to look at a fictitious case. Let's take a fictitious case, and perhaps we'll look at what exactly the financial investigator, what would be his role here? What about, this is why I'm talking about institutions, the institutions that should be in place, the intelligence institution, the police institution, the anti-corruption institutions, the legislation that would sort of bond all these players. But then these are investigators, but they do not exist in a vacuum. The central bank, all the banking sector, and the regulators of the banking sector, the regulators of the financial services, all these people have to be able to have a round table and be able to share this information so that there's a clear objective, a clear roadmap as to how to go about investigating the money stolen and transferred elsewhere. Now, let's say the project is a project of a dam, which costs about 500 million. That's the project, and of course, there is this high official whose signature has to go on the contract. So he's the key person to sign this, and of course, he's given a large sum of money, and that, of course, he would want to dissipate that in other jurisdictions. The first objective would be to create this nexus, this link between the money stolen and the money paid by the briber, the multinational. You must link it to the high official. And of course, you must link it in the context of this project for the construction of the dam. So that would be the objective. Create the link. Once you create the link, you will have to trigger the financial trail. So that's the first of everything. That would be the first thing. Now, your legislation must be able also to provide a panoply, an arsenal of ancillary orders. Why do we need ancillary orders? Because once the investigation starts, the money can disappear. There must be an order against the bank, but before you can order the bank, or you can order financial services, or you can order any other third party, you must be able to lay the foundation of suspicion that this money was the money paid as bribe for the purpose of the construction of the dam and paid to this gentleman or paid to third parties. So this is your first step, and you can only achieve this through very training, which is strenuous training. You must be able to get people. Today, technology, which is moving at such a fast pace, is the gate to so much information. Now, if you don't get your IT people to start doing investigation in this web of the way the money has flown through the system, you will be at a big disadvantage. So you will have to combine this. And it's only through a coordinated approach, because you can't expect the IT to be doing the investigation themselves, but they can take you to this fountain. So what are the ancillary orders must be available for a quick injunction. In some countries they can call them the Mareva orders, but there must be injunction to freeze. Once you trace, you must be able to freeze some of the suspected assets. And also that you must be able to surround the close associates, the family members, the business entities such as trusts, foundations, and other corporations, which will be the target of any investigator. Now, what are the red flags? The red flags are very, very important, because the investigator will have to watch the lifestyle of that person. It's very simple, because if there's a mismatch between him as a PEP, a politically exposed person, a high official whose remuneration is publicly known, and he's driving, let's say, expensive cars, his family or his children are displaying a wealth that do not match the kind of income that this person would be earning, these become the red flags. And of course, traveling abroad, business card, credit cards, and whether they have been contact with lawyers, with bankers, with stockbrokers, and all these things are the red flags of what an investigator should be looking at. This is the first thing. Now, of course, the countries, whether if the money is in some offshore accounts, I mean, a good way is to know the countries where it has been, and then to go to some of the information available in the public domain, land registry, purchasers, other people in the name of, can you link it to the name of some of the professionals who are in contact with these people? So, like I say, whether they have purchased, there's 10 apartments in Europe, and all these things, the lifestyle is something which has to be thoroughly investigated. And of course, there will be records on the laptop, on the computer system. There will be invoices, there will be checks that are paid, there will be the accountants. All these things are potentially small clues of evidence that can lead you to the bigger picture. These small clues, when you piece them up, it's like a puzzle that can lead you to the larger picture. Am I doing for time? So now, so what are the avenues of cooperation? It's, I've just mentioned the multilateral treaties. You can even go for voluntary arrangements. There's nothing that two countries cannot, between agencies, between states, there's nothing that stops them from coming to their own arrangements. Bilateral treaties now, the Memorandum of Understanding, the national law, with or without a question of reciprocity. They take, for instance, the Harare scheme for countries in the Commonwealth. You also have issues with the French countries. They have similar arrangements. So all these are potentially tools for you to which avenues which you can borrow to go and seek the assistance of jurisdictions. Now, what are the kind of evidence you can ask for? I'm going to go very fast. I'm sure you're all familiar with this. Now, of course, the executing, you can ask for the execution of searches, seizures, the examination of objects, evidence, witnesses, and so on, and seizing and freezing of assets, facilitating the voluntary. And of course, in practice, I've gone very fast with that. Can I have the next slide, please? That in practice, the main protagonist would be the central authority. There will be different steps. You can ask for a commission rogatoire, or you can ask for this mere taking of evidence, and it will be central authority talking to central authority, and they can liaise, and then it will be the next step, investigator talking to investigator, and this can go on between them. But this is at the level of investigation. This is at you have done your request, you are talking, you are freezing, you're trying to trace, and your battle starts as from now. So the battle starts as from now, and it's a hurdle of procedures, of lawyers, accountants, specialists, all kind of professionals, and the battle will start in court. Then you can have informal requests. My colleagues was talking of informal requests this morning. You can get informal requests in all these amongst agencies. You can this. I'm not going to go to this. You have on top of that a number of organizations which can be tremendously instrumental for you to share evidence, to get evidence, to look for witnesses, like the Egmont Group for for financial intelligence unit in your country, the Interpol, the Europol, some of the countries where some budgets are concerned, maybe EU, where the EU budget is concerned for financing the dam. They may also be interested if it's their money that was in the first instance financing part of the project. They may be interested to help the Olaf and so on. These are a number of potential agencies which can come into play. And of course, the next thing is you would want, once you started, you will have to go through the process of tracing, freezing, confiscating, and of course you will have to it's a long battle before courts. It's going to be complex. It's going to be very expensive. I mean, just to give you an idea, the case of I know the case of the Marcos from the Philippines. Up till now, only part of it has been repatriated. Up till now, the money is still pending in some of the banks in Switzerland. So just to give you an idea is that it's always a battle which is complex legally, forensically. It's an expensive process, and for instance, the legal action over 200 million that the UN estimates from a former Ukraine prime minister still going on. That was in 1990. Up till now, there's no sign of this money. I want to end on this, if you allow me, Chair. I'm already...
Please conclude, because we're running out of time.
Yeah. My answer, I see a lot of answer with the unexplained wealth orders. Unexplained wealth orders, it's an action in rem. You go after the property simply based on the fact that a person, if he has emoluments, or anyone, let's say someone has stolen money and placed it in the name of an immediate family member, you can ask that person to explain where on earth has he got so much money. That's the end of the matter. You don't have to link any criminal. You don't have to place any evidential foundation. The mere fact that you can establish that he is living beyond his means, in Mauritius, our law is draconian. If there's no need to establish a criminal link, there's no need to show that it was tainted money or the origins. The only thing that you have to establish that it was disproportionate to his emoluments or other incomes, and it cannot be satisfactorily explained. I'm going to stop here because I know I have abused my time. I will, of course, join the debates if the need arises before later. Thank you very much for your attention, and sorry for taking too long. My apologies to my panelists.
Thank you very much, Borel, and I hope that the organizers will help us and circulate this presentation to all of us. It's very informative and helpful. Allow me to start with Mohammed, who is going to share with us the experience and best practices in recovering proceeds of crime held in foreign jurisdiction. The floor is yours, Mohammed.
Thank you very much, Mr. Chair. My distinguished colleagues, ladies and gentlemen, good afternoon. I've been asked to present my intervention in English, which I was not well prepared to speak in English. So please forgive me for my poor languages. At the beginning, I will try to speak about the best practice and the experiences of the assets recovery, which we have been tried in Egypt, and the role of the Egyptian public prosecution in this kind of international cooperation. I will try to speak short and going to the point. Let me start about the international framework which we are building, or the legally binding framework. We work under two pillars: the United Nations Convention Against Corruption, the UNCAC, and the United Nations Convention Against Transnational Organized Crime, the UNTOC. The issue of assist recovery or return the proceeds of crime considers and concentration of international judicial cooperation should be on three reasons. The first, depriving the perpetrators of the crime of the fruit of their criminal enterprise, and the second, the return of these criminal proceeds to the states from which they were planned, in order to confirm the existence of international judicial cooperation. The third is that the recovery of criminal proceeds is itself an anti-money laundering phenomenon. I will also move on until the useful ideas and good practices. Okay, after the changing the regime in Egypt at 2011, there were a lot of corruption cases have been arised, and the criminal investigations shows that there were hundreds million of dollars have been transferred to another country. So there were a challenge in the investigation how to recover such stolen money. So there were a big challenge in these cases, and regarding OR as a best practice, the idea was creating a specialized committee which have been established by law at 2015. The Egyptian law have been established a committee aimed to coordinate all the national efforts in the assets recovery and representing the Egyptian government abroad, and to develop also a national strategy to improve the mechanism of the assets recovery. In addition, in its mandate also allow to negotiate settlements with the defendants who are listed on the sanctions listed abroad. At this period of time, the committee have already asked for international cease orders, and the president of this committee is the Prosecutor General of Egypt, and the committee started working on the process of the international cooperation on the assets recovery. This process made, in our point of view, a big success, because we managed and success to recover 9 billion Egyptian pounds, which means they are, and also we have also returned $600 million regarding of these corruption cases. So this commission worked now for 8 years and made a lot of success and victorious through this idea. Another case study I would like also to arise, that's which we think it's a little bit different, because I'm not talking about recovering money or the kind of sort of money laundering or so. The case was, I will talk about case which is a successful case. Please return to the previous, yes, thank you. The case was about recovering an Egyptian antiquities which have been smuggled before 2019. The summary was, by coincidence, in August 2019, there were a report received from the guards of a palace in Paris, France, regarding that there were an involvement of an owner of this palace, and he was deceased, and one of his friends, which is going to be accused person at the next phase. The information was that they was working at transfer, that there were a transfer from the deceased person to the accused, a palace, and the palace was containing a lot of Egyptian antiquities. The pictures which we received was examined also by the technical committee from the Ministry of Antiquities, and it was being found that they were being they are belong to the ancient Egyptian civilization, pharaonic civilization. The case started, next slide please. The case started with investigations at the Egyptian Public Prosecution, and at the first phase, the investigation was working on capturing the accused and also taking the, all the measures and procedures needed to freezing the assets in France, then take the other procedures and measures to prohibit the accused persons from traveling from Egypt. After that, the the judicial cooperation steps started. Next slide, please. After after freezing the Egyptian antiquities, a mutual legal assistance was started, and there were the main problem is how to how to create the connection between the acts of stealing such antiquities from the organized group which been involved in that in Egypt and smuggling it to France. After building this MLA request, which have all the ideas needed, and they started to be sent to the French authorities, and they already freeze the stolen assets, and quickly they are, and we had also a decision to return such asset to Egypt. Next slide, please. The MLA request was a little bit problematic because I'm talking about smuggling of antiquities which have not been covered under the United Nations Convention Against Corruption, and also not under the UN Convention Against Organized Crime. So we built our MLA request on the bilateral treaty between Egypt and France, and we used the UNESCO Convention, which convention have been established in 1970 to make a protection for the intellectual properties. We used that. After that, we managed to recover such pieces. So, and there were a delegation under the presidency of Prosecutor, His Excellency Prosecutor General of Egypt, traveled to Paris with a committee, an ad hoc committee from the artificers authorities, and the delegation made the inspections of the artificers and returning the number of 114 pieces of artifacts. We thought, or the manage of returning such cases, it was like a message for the world, because we found out that the Convention Against Corruption and against organized crime was not enough to cover all kind of smuggling of other assets which has not been a result for a corruption. So that Egypt has adopted a resolution at the United Nations Convention, United Nations Conference of the Party at 2022 for the organized crime. And we have also adopted a resolution regarding to studying or creating a work group to make a wide vision for another kind of organized group which they might be working on the intellectual properties. Thank you very much. I try to be super fast, and forgive me for my poor language. Thank you, Mr. Chair. Thank you very much.
Thank you very much, Mohammed. Thank you for your discussion, especially that inspiring experience and case of recovery of Egyptian antiquities. Let me now request the DPP Zambia, my brother Gilbert, to share with us the experience.
Hello? Oh. Good afternoon. I can promise you I'll be very brief. I am very mindful of time. I think thanks to the two speakers that have laid the foundation for us, I think that this is a very serious and very important topic of discussion. Mr. Boley already laid the foundation of a Zambian case involving a former Zambian president, and he alluded to a sum of $1 million United States dollars spent on designer suits. Well, it was more than that. What happened in that case, in fact, was that the Zambian government instituted a civil action in the High Court in London in 2006. This action sought to establish liability on the part of the former president and nearly 20 of his associates. Now, allow me to digress at this point and perhaps pose a question. Regarding asset recovery, what we've been doing, even on the continent, perhaps the question to pose is, has it worked? Are we recovering the assets? It's a question I'm posing. Has it worked? Are we getting results? Now, if we are not getting results, we must be asking ourselves, why are we not getting results? Yesterday I was engaged in some conversation. I do not have the empirical data with me, but I heard that of all these pilfered resources and assets, we are recovering about 1%. So, if something is not working, why are you persisting with it? We need to interrogate. And I think this is the gathering where this interrogation ought to take place. Continentally, what is it that can be done to ensure that we succeed on this score? Now, back to the Zambian case. It was run on two bases parallel. So there was a civil action in London that commenced in 2006, and recoveries to the tune of about 46 million United States dollars were made. But this was over a long period of time. We had parallel criminal proceedings in Zambia, where after so many years, the former president was acquitted. But the civil action that commenced in London, culminating in a forfeiture order in the Zambian court, an order from the UK being registered in the Zambian order, led to forfeiture of his assets. There were challenges by the former president, and the final decision was only delivered in 2021, if I'm not mistaken, from 2006, culminating in forfeiture of his assets. So you can see the number of years that it took for that civil action to terminate. Now, my concern is, obviously, what would be the best practices? What should we be looking at as some of the best practices? Or what should we be interrogating? How do we make this work? We propose that there should be direct asset recovery by victim states through the courts of other states. I know this is unique, and but what we need to avoid is the protracted and bureaucratic procedures that have been typical of transnational asset recovery. Now, in this direct asset recovery, where a victim state actualizes it, we are suggesting that it should be done by means of a victim state instituting civil proceedings in the domestic court of another state. Zambia was able to do so in the UK. Why can't, for example, Rwanda do so in Kenya, or Rwanda do so in Mozambique? Why should it be in Europe? We should be able to do so continentally amongst our states. And a domestic court order for restitution to the victim state by the convicted person or judgment data must be able to issue. And also, we suggest that domestic confiscation proceedings should recognize the legitimate claim of the victim state or public international organization which may be cited as a third party. We also propose extraterritorial jurisdiction should be granted to the courts. Now, this will give these courts the ability to exercise jurisdiction over individuals or property located outside the geographical confines of the jurisdiction. We appear not to be doing so much of this. The whole system is so bureaucratic. And I think that we must agree that we need to reform the system. And countries, like the earlier example I gave of Zambia, should be able to have authority to enforce foreign provision orders to do with confiscation. We pray and hope that our laws can eventually be flexible and simple, where we use more of statutory instruments rather than parliamentary legislation, which brings in a lot of bureaucracy and is quite lengthy. Because the ease and speed with which assets can be transferred from one jurisdiction to another requires that our forfeiture laws are simple, they are nimble, they are malleable, and easy to respond at a short space of time. I will end here. I don't know whether it was the presentation was being beamed, but thank you so much for listening. Thank you.
Thank you very much, Gilbert. Lawrence, the floor is yours.
Thank you very much. It's a great honor to be here. I wanted to extend my thanks to DPP Haji for inviting me to be here and being such a great host. I'm grateful to my friend Marcus Green for having made an introduction. I wanted to give you a little precursor to the things that he said and why I think it's important that we pay attention to Africa. And it didn't really start in Africa. It started with Mexico. And Mexico expanded to El Salvador. And the story I have to tell is about El Salvador. And I was invited by the Attorney General of El Salvador, along with the AGA Executive Director Karen White, to go to El Salvador. We were there before Christmas several years ago. And he was under extreme political pressure because he wanted to file criminal charges against a former president of El Salvador because, among other things, $10 million in foreign aid had come into the country, never actually made its way into the public treasury. Instead, it ended up in a series of Caribbean bank accounts, all under the control of the former president. Now, in the United States, we have a name for that. We call it stealing. And that's what happened. He stole the money from the public, but he also stole the reputation of El Salvador. The AG was under great pressure. I was there to bolster him. We have pictures all over El Salvador. I didn't do anything to help with the case other than that I was there with the Attorney General of El Salvador, lending credibility. That case was filed and it's still ongoing. However, that's not the only thing that happened. We were there a few weeks before Christmas, on December 25th, and on Christmas Eve, El Salvador Attorney General was doing a wiretap on a criminal gang called MS-13. Very, very violent group of people. In fact, to prove how tough they were, they kidnapped a busload of innocent people and slaughtered everybody on the bus. Now, from my perspective, it doesn't prove how tough you are when you can shoot innocent men, women, and children who are captured on a bus. They're unarmed, and there's nothing brave about that. You prove your depravity, but you don't prove your bravery. What happened then is, as they were doing the wiretap, the El Salvadoran AG, he heard them order the assassination of a witness against them. That witness was located in the state of Maryland in the United States. Because of the holiday weekend, the El Salvadoran AG was not able to get hold of anybody else from the State Department, but because I had been there and Karen White had been there, the executive director, he knew who to call. And he called Karen, she called the Attorney General in the state of Maryland, who called the Maryland State Police, who showed up at the witness's house and collected her and her family, put them in protective custody, and the next morning MS-13 showed up at her house to murder her. Not only were we helping our colleague in El Salvador fulfill his function as a prosecutor, but in return, what we got was cooperation that saved the life of a human being. So what does it take to have this kind of international cooperation that we're talking about? The first thing that it takes is a prosecutor willing to stand up for the rule of law. And sometimes that requires that prosecutor to stand all alone. The other thing it requires is that association with political and policymakers, that they too have to stand for the rule of law. And what kind of things do we need to have that happen? Mr. Buriel, who is in the Senate of the International Association of Prosecutors, he and I have something in common. I have for many years been the National Association of Attorneys General representative to IAP, and one of the things they emphasize is MLATs, Mutual Legal Assistance Treaties. That's what we've been talking about. And to see that your country, your state is cooperating and agreeing to cooperate with other states. There's also a number of conventions that are worth considering. The United Nations Convention Against Transnational Crime. Most African states are members. There are two primary exceptions. The United Nations Convention Against Corruption, the Convention Against Illegal Traffic in Narcotics, and the International Convention for the Suppression of Terrorism. So there's many avenues that we have to cooperate with each other. And that is, we also need to be able to look each other in the eye. I need to be able to trust you. You need to be able to trust me. You need to be able to pick up the phone and call me. I need to be able to pick up the phone and call you and know who you are on the other end of the line. We can do that by having the conversations that are necessary. I am very grateful to be here. I hope my comments have been helpful. I am proud of my colleagues to be here with you. By the way, I've been to Egypt, amazing country. I got to spend 3 days in Masai Mara here in Kenya. If you want to have just an absolutely mind-blowing experience, go and sit next to a lion. It's great, I'm telling you. Anyway, thank you very much.
Thank you very much, Lawrence. Now it's time for participants to give comments on this topic, or even if you want to ask any question, please feel free. So the floor is yours. For anyone who wants to give a comment or ask a question, please raise your hand, and the organizers will facilitate and give you a microphone. Thank you.
We must be brilliant because there are no questions. I'm making a joke.
The Prosecutor General of South Africa.
Well, we answered all their questions, or we're really boring.
Okay, this is better. Now, I didn't want to put my hand up because I was hoping that we'll have more engagement from the technical people, but just to continue the conversation, I think the point that the DPP from Zambia, a critical question, and I think that's something we have to ask. We all talk about collaboration, we all talk about cooperation, and there's a lot that's happening. It's not like nobody's not doing anything. There's a lot going on. But why is it that such a small percentage of assets that are stolen finally are recovered? And I think it's the World Bank that said it's about 1%. I mean, that is, we all should be ashamed, actually, that so the question you ask is the right question. What are we doing wrong? Why is it so low? Is it because, as prosecutors, we can do so much? Is it a matter of international cooperation? Is it a matter of political will? Do we need the African heads of state to and the next, I don't know what happens, I've never been to one of those meetings, to make commitments around, collaboration, because ultimately mutual legal assistance does become a political issue. So, I think we really need to think hard and fast about how we can, do lots of things and continue doing what we're doing. We can't stop it and do as best we can. But that question needs to be answered, and I don't have the answers, and hopefully some other colleagues would be able to. The other question I want to ask, and I'm hoping that some of the colleagues here with their experience would be able to assist. There seems to be an inclination, we were chatting a little bit about it over lunch, for big international law firms to approach countries where they know there's been massive looting, including like South Africa, to assist with asset tracing and recovery at a sort of no recovery, no fee basis. But of course, if you do recover, there's a percentage and there's expenses, etc. And to understand if there have been experiences with this and whether, what colleagues think about it, because we've had a number of approaches and we kind of cautiously maneuvering in this space, and because we do want to work with governments. Ultimately, we want to work, but MLAs are very slow. But what makes that faster, if it is faster, or is it not? Just to understand what the experiences might have been. Or maybe one of our panelists might be able to assist in that kind of area. Thank you.
Thank you very much. I think DPP Zambia, we get time to react. I would like to take 5 questions or comments, and then the presenter or other discussant will be able to react when we will be concluding. Now the next is Sibo from Rwanda.
Thank you so much. I liked the DPP Zambia's suggestion of territorial jurisdiction. And this ran to my question of how can we engage Western banks, the Western countries' banks, which seem to be having huge amount of money stolen or recovered from Africa, and they are not giving Africa this money back after the fall of some of the presidents that got this wealth. How can we engage or ask these banks to volunteer and give us information which the prosecution would capitalize on to investigate? Another question would, if, for instance, they don't volunteer this information, could there be another level of engaging them, and perhaps is there any crime associated with complicity? This is my question. Thank you so much.
Thank you. We do have, okay, thank you. Please introduce yourself so that we can know who has asked the question or giving comment.
Sim, obrigado. Eu sou procurador da República de Moçambique e sou.
Can you wait a bit so that we can put our...
Okay. Dizia, sou procurador e diretor do Gabinete de Combate à Corrupção de uma das províncias de Moçambique. A nossa preocupação em Moçambique tem, de facto, a ver com a recuperação de ativos.
When the colleague from Zambia was talking, I have a feeling that this is a general concern that they are recurring. Since I talked about the problem of banks and the function that they have and the role in this type of crime, but that talks about another problem of the money that is also the bank is the kidnappings.
Não será esta oportunidade, por via deste órgão, produzir uma recomendação para os Estados no sentido de encontrar forma de responsabilizar os bancos no que tange ao controle dos valores que circulam fora do banco e também dos que estão dentro dos bancos, porque se há dinheiro que sai por intermédio do banco. Então, como é que sai? Será que eles estão alheios a esse combate? Muito obrigado.
Thank you very much. I can see the DPP South Sudan.
Okay, thank you. My name is Deng Ashwil. I'm a Director of Public Prosecution, South Sudan. Yeah, it is good for the presenters covering the issue of illicit the financials abroad and especially the case of South Sudan. We came here and we meet every year and we talk about the modality of the asset recovery. There were some challenges facing South Sudan as a new country in case of recovering the assets, especially cases of corruptions of some individuals inside Sudan. They committed the crime and they illicit the money outside South Sudan to the neighboring countries, especially our neighbors here in Kenya or to Uganda. This illicit the money, they were not following the process of the bank system. They just only took the money as in cash, in dollars, and then they transferred it outside. When we traced them in investigations, we discovered that they registered some companies abroad. And the bureaucracy of corresponding between our counterparts is become bureaucracy. You write to the Minister of Foreign Affairs, then to the embassy of that country in our country, and then to the counterpart Minister of Justice, because South Sudan has still the Director of Public Prosecution is under the Minister of Justice. So that is very independent to communicate it with our counterparts, deputy or DPP in these neighboring countries, so that we have to follow it. This bureaucracy corresponding to the Minister of Justice, Minister of Foreign Affairs, then to the embassy of that country, and then it took times. The response of the requested took a lot of, and then always cases are dying up without ending to the needed cooperation between our neighboring or the counterpart of DPP in the regions. So this one. Secondly, South Sudan facing also, we are not signatories to United Nations on organized or combating organized crimes. We are not part of it. We are just only making process to be a member or to send that international convention. It is good that South Sudan is a member of anti-corruption convention on combating corruptions. It is good. We have that one. So let us have good recommendation. When we come to this forum, we have to put them on action points in the at the end of the any conference that we are dealing with it, not to be just only talking, but to share it as really information to recover the assets. Thank you.
Thank you very much, DPP South Sudan, for your input. Let's take the last. We're gonna take only two. One from DPP Zimbabwe and then another one. We're gonna take three and we conclude. Another one there, and DPP Tanzania, we conclude the comments and questions from the participants. Just three.
Thank you, Mr. Chairman. My name is Nelson Mutonziwa, the PG, acting PG from Zimbabwe. Yes, I heard the question being posed that why are we recovering less? But I think from the first speaker's presentation, he mentioned that the theft of this money is done by very intelligent people. It's in a sophisticated way, in a complex way. So the investigators must be sharp. If you investigate and you don't find something which was stolen, it means you have to upskill yourself so that you can be able to identify the stolen item. He also went on to mention the difficulty in differentiating or separating legitimate money from illegitimate money. It's a complex issue. It's not all that easy again. I think we have to upskill ourselves. The investigators must sharpen their minds so that they are able to penetrate, that system. Because, mind you, we are not talking about unsophisticated people. We are talking about sophisticated people who are being assisted by sophisticated financial institutions who are benefiting from these crimes. So when pursuing such money, we must be also equally sophisticated. It's not easy. That's why millions are going out and a few millions are recovered. I think we need to do more on that. I thank you.
Thank you very much. Introduce yourself.
Thank you very much, Session Chair. My name is Hilary Sigay. I am the chairman or chairperson of Justice and Legal Affairs and Human Rights Committee in the Senate of the Republic of Kenya and the Senate of a county called Bomet, which is in the South Rift or Rift Valley of the Republic of Kenya. I've got two comments which I would request following the presentation from Honorable Satyajit Bolel, which the rest of the panelists also spoke into. When he mentioned about the common threat to the element of repatriation of the proceeds of crime, one of which is, of course, the complexity of the entities and the players or partners that are involved in the whole of this complex web of crime. What is the place of attorney or advocate-client confidentiality when it comes to elements on that conversation? What do you comment about the data protection laws, which is an emerging area across the region, and also being a challenge as a financial institution, they've got the legislations on the ease of business, where at the click of a button lately, you can set up an entity with corporate personality and it can trade immediately upon its incorporation. I would wish to hear your comments on those three items. Thank you very much.
DPP Tanzania and the President of East African Association of Prosecutors, the floor is yours.
Thank you very much, moderator.
I just wanted to comment on why are we not doing good in asset recovery. As I can see, there are two major issues here associated with our performance in asset recovery. As one of the speakers commented, in most of our jurisdictions, asset forfeiture is conviction-based. We must establish with enough evidence that these assets are proceeds of crime. But as commented by the acting PG of Zimbabwe, most of our investigators are not conducting parallel investigations. We only end up investigating and getting evidence of the offenses, tax evasion, corruption, and then they end up there. So it is difficult if you come up, you want to forfeit the assets, you want to recover the assets, but there is no enough evidence associating the assets with the crime. I think we must put more emphasis collecting evidence to make sure that we recover these assets. And secondly, Chairman, I want to comment a little bit on MRA. Most of the DPP's office are central authorities. There is delay in getting assistance and getting evidence from a foreign jurisdiction. Maybe we may think of coming up with a strategy. Once you get the request from your counterpart in other jurisdiction, we make sure that the request is processed quickly and the evidence is corrected. Otherwise, if it takes 2 or 3 years to get the evidence, chances of succeeding also become low. Thank you very much, Chairman.
Thank you very much. Allow me to ask our panelists, for each of our panelists, if you think that there is a question you can respond or react of any comment from the participant, please do it, but you must conclude with a recommendation that can help our public prosecution in Africa to deal with this issue of recovering proceeds of crime held in foreign jurisdiction. And I'm going to start with Lawrence.
Thank you. I have 5 words, really. Courage, cooperate, convince, procedure, and proceeds. That is, have the courage to pursue the rule of law, pursue those proceeds, file the criminal charges. Second, cooperate. That is, if you have a need, reach out, let others know so that they can help you. There's nothing wrong with that. If one of your neighbors, neighboring countries, wherever it is in the world, needs help, cooperate with them. Convince the political powers that be that this is worthwhile. Procedure, we must work together to formalize and streamline procedures so that you don't have an action filed in the Philippines in 1985 and the return of funds in 2002. The proceeds, share the proceeds. If it's appropriate, it should be appropriate. The United States has done that with other countries. That is a way to help that whole process work. A few moments ago, I noticed all of us up here had our right leg crossed over our left leg. It was natural. It was not rehearsed. It was synchronized, but not rehearsed. It's because that's who we are. Everyone in this room, we're here because we care about the rule of law. It is natural to us, and that's what we should pursue. Thank you.
Thank you very much, Lawrence. I hope that the organizers are capturing these recommendations because they may be helpful in our resolutions for this meeting. Gilbert, I think there were some few questions that were addressed to you, and you end with a recommendation that can help us.
Indeed. Thank you so much, Mr. Moderator. I think that the question, which is an elephant in the room, to which there are no obvious answers, is what do we do with these very minute, inconsequential recoveries? It's almost a rhetorical question. I do not have a precise answer, but because I believe that we must be dealing with practical aspects, practical things, tangible, we must be able to come up with tangible solutions to make our interaction meaningful. The reason why we gather must in the end become meaningful. And if we do not have obvious answers, we must be able to commission a study, put together a study group, or put together a task force to interrogate the question, so that in the end, that group perhaps can report back and say, this is the way we should go in ensuring that we enhance cooperation to ensure more recoveries and more interaction. But of course, we cannot discount the fact that we will need political will in almost all jurisdictions to ensure that this is actualized. There was a question somewhere in the middle there regarding how we engage with, I think it was Western countries, regarding stolen and recovery assets, because it takes too long. One of these is to work with organizations that can help us, especially on the investigative side. For example, here I'm thinking of the IACCC, based in London, where all major investigation units in the world are represented. I also have in mind the Globe Network, which has that informal interaction where the emphasis is so much on informality in terms of exchange of information or acquisition of information. So I think that we will need to network more, and as it's been said, enhance and deepen informal networks. I appreciate the answer that was given from the DPP Zimbabwe, that we need to upscale, we need to beef up our skills. I cannot agree more. And I think this is one of the forums that can be used to ensure that we identify some of those areas to capacitate us and for capacity building. And even regionally, we need to work closer in ensuring that we are interacting more with our investigators and helping to ensure that they are retooled and their skills upscaled, like you put it. Mr. Moderator, thank you.
Thank you very much, Gilbert. Mohammed?
Thank you, Mr. Chair. في البداية أنا طبعا بتفق تماما مع زملائي وسيما سعادة المدعي العام لزامبيا في ضرورة الاستفادة من دور الشبكات الإقليمية، وبالفعل التجربة العملية أثبتت أن الشبكات الإقليمية في المساعدات غير الرسمية لها دور إيجابي.
It's very important that we should benefit from the collection.
في جمعية النواب العموم الأفارقة في آلية التواصل المباشر أو استخدامها في التواصل المباشر فيما بين أجهزة النيابة العامة الأعضاء، وفي إيجاد آلية أو في إنشاء آلية على المستويات الثنائية في المشاورات فيما بينهم في إيجاد طرق حل لهذا الكلام. سيما وأن الجمعية أبرمت مذكرة تفاهم في العام الماضي مع جمعية النواب العموم العرب، ونصت مذكرة التفاهم على أن الجمعيتين يتبادلا نقاط الاتصال، فأصبح لدينا كجمعية نواب عموم أفارقة سجل لنقاط الاتصال يجمع بين الدول الأعضاء من أفريقيا، وأيضا نقاط الاتصال في الدول العربية الأعضاء في جمعية النواب العموم العرب. التوصية اللي بقترحها على حضراتكم أنه التأكيد على ضرورة الاستفادة من هذه الميزة أو هذا الشيء اللي موجود في التغلب على التحديات الناشئة عن مسائل استرداد الأموال بشكل عام. شكرا سيادة الرئيس.
Thank you very much. Borrell.
Thank you. Just to wrap up, most of the things have been said. I identify a few things like formal and informal cooperation. I think we've spoken lengthily about that. Within the country, there must be a coordination of all law enforcement agencies and parallel investigation to take place at the same time. Joint investigation, we must be more open to accept the presence of investigators overseas to come along our side to conduct joint investigation. The money trail, the information, all take dollar notes. The money trail can be easily assisted by the Department of Justice in the United States. Training, forensic and auditing a trail that to follow the trail of the money. So training and formation of investigators. And I was always had in mind that for the regional, for our region, we should have something similar to an Afrojust, to an Eurojust. An Afrojust where we can meet, investigators can meet and bring and share cases which involve their jurisdiction. And finally, I think we should all follow the example of Kenya for good governance. There must be only two-term mandate for political leaders. Thank you very much.
Thank you very much. Dear participants, allow me to thank the panelists. We started this session with a delay of 30 minutes as we were discussing the recovery of proceeds of crime from foreign jurisdiction. So the panelists managed to recover only 15 minutes among the 30 minutes that we wasted during lunchtime, and we hope that the next session will help us to cover the remaining 15 minutes. Thank you very much, and God bless you.
Good afternoon. I hope you enjoyed the presentations. Please let's stand up and stretch. The moderator for this session will be and to the stage, I would like to invite Mary Motinyane, DPP Lesotho, Jacinta Nyamosi, Deputy Director Kenya, Mohamed Habib, Chief Prosecutor in the International Cooperation Department in Egypt, Alex Osunga, Security Operations Center Technical Lead. And our discussant this afternoon will be Lady Mudeu Himulu, expert in cybersecurity. Something to stretch people. Yeah? Anything to stretch people. Let them sing, let them draw, let them whatever. They can write Africa with their heads.
This is not part of my session, but she has told me everyone should be standing up. Let's all stand up. Let's all stand up. and we are going to write Africa using our heads. Can we start? Using the heads, no hands, just the heads. A, cross, F, R, I, that's easy, C, and lastly A. Perfect. Okay, let's be seated now. Let's be seated now. One more person is not there. It's you. Yeah, I thought. Okay. The last session for the day. A very difficult time to present, or maybe a good time too, because most people will be sleeping. Session 2, and the last one for today, is technology as a facilitator for transnational organized crimes. We have 1 hour, 15 minutes given to us, and it will be divided this way. The presenter will use 15 minutes. The panel discussants will use 7.5 minutes each, and then 30 minutes will be for plenary, because we want to hear all the experiences from this very colorful session this evening. I will not, if you go into your books, I'm not going to talk much about the presenter and the panel discussants. You can just go on page 16. Page 37 of this, the book. It has all the bio of the presenter. Ms. Chimulu is one of the few trained cybersecurity experts in Africa. So we have the best today. And in 15 minutes, she will be able to impart on us this much needed knowledge. And then on the next page, you will get more about Ms. Jacinta. She's the Deputy Director of Public Prosecutions of Kenya. She'll be also one of the discussants. And my sister Mary, Director of Public Prosecutions, Lesotho, will also be a discussant. And last but not least, my brother Mohammed, Chief Prosecutor in the International Cooperation Department of Egypt. And he's not here. I think he's not here. Last but not least, we shall have Mr. Alex Osunga. He's the Security Operations Center Technical Lead. He will also be one of the discussants. Without taking a lot of time, I want to invite my sister to come in 15 minutes and dissect for us cybersecurity. Being an expert, you're most welcome.
Thank you very much. I know when you hear technology, we've had the president, you've had lunch, there's Mombasa heat. I'm going to try and make it fun. And just as a precursor to this presentation, it's not going to be hard. I'm a lawyer doing cybersecurity, so it means that it's going to be possible for all of you to understand too. So I don't know if my presentation, the slides are up. But I'll just jump straight into it. Obviously, when I'm presenting in a room full of lawyers and legal minds and judges, I need to put a disclaimer that all the images used in this presentation are acknowledged, and there is no intent to infringe on any copyrights. Further, the images may not depict the actual topic being discussed, but are for illustrative purposes only. And if you go to the next slide, you will consider the images acknowledged. Let's get right into it. Cybersecurity plays a critical role in the criminal justice system, particularly in the area of effective prosecution. by collecting, analyzing, preserving digital evidence, and identifying and tracking suspects, and implementing security measures to prevent cybercrime, cybersecurity experts can help ensure that justice is served. So before I give you my elevator pitch version on how you can convert, handle, and preserve and adduce digital evidence in court, because time is not my friend today, I think it's only prudent that I give you an overview of how cybersecurity can help you in collecting this evidence that you're going to adduce in court, and how it's also going to help you in identifying and tracking suspects. So we can go to the next slide on evidence collection. Examples of some of the various tools and techniques that digital forensic experts use to collect and analyze digital evidence include something called computer imaging. And this involves creating a copy of the entire contents of your digital device, including the operating systems, the applications, and the data. It's the equivalent of when you go to your photocopying machine and make a photocopy of your paper. That's what we do when we do computer imaging. And the image that is created can now be used as evidence in a criminal case. Then we have data recovery. This entails the use of specialized software to recover deleted or lost data from digital devices. And later on, I'm going to talk about file carving, because sometimes your criminals will try and delete their data from these digital devices, and yet you need it to be able to effectively prosecute them. And this data recovery can be recovered from everything, from your files, from your emails, all sorts of digital information. And finally, I'm going to talk about network analysis. This pertains to the analysis of network traffic to identify and track your suspects. This includes analyzing their IP addresses, your email addresses, and other digital identifiers so that you can identify the suspects and track their movements. If we can go to the next slide on identification. When it comes to identification and tracking of suspects, cybersecurity is very helpful because it helps you track them through what we call their digital footprint. And there are different ways we can do this with cybersecurity, and I'm going to cover 4 today. One is digital forensics. This includes analyzing the IP address, email, digital identifiers, network forensics. This entails analyzing the network traffic to identify the suspects, track their movements, and we do this by analyzing their IP addresses, things like their ports and protocols, and this helps us also identify patterns of suspicious activity so we can know where to go. The third item I'm going to talk about is IDS. IDS are intrusion detection systems. And these are used to detect and alert on suspicious activity on a network. This includes analyzing network traffic to identify patterns of malicious activity, such as attempted hacking and malware infections. And malware infections is when a virus, the same way in COVID you got the virus in your body, malware is the virus getting into your digital systems. And the final one I will talk about is log analysis. And this involves a review of the logs, similar to what you do with regular evidence. But this is from network devices, such as servers and routers, to identify patterns or suspicious activity and to track the suspect's movements. Now that we know that we can collect evidence and we can track the suspects, how do you convert, handle, and preserve and adduce this electronic evidence in court so that Madam Justice does not tell you it's inadmissible? So prosecutors and judicial officers need to be conversant with the best practices, and this includes conversion, handling, preservation, adducing, chain of custody, authentication, and legal compliance of e-evidence to ensure that it can effectively prosecute and convict the internet desperados. As cybercrime, apart from the mental and physical anguish it causes people, in Africa, we're actually losing $4 billion annually to cybercrime. On the global stage last year, we lost $6 trillion. And this is even before we bring in technology like quantum computing, which is going to really enhance cybercrime. Or even everybody's talking about this AI chat GP, which has advantages, but is also giving cyber criminals an easy way to create these nefarious things to enhance cybercrime on the continent. And just for perspective, Africa is being hit hardest. We're hit hardest on the global stage in terms of cyber incidents. And a cyber attack happens every 39 seconds. But I digress. Let's get into digital evidence. E-evidence can be converted to a format that's acceptable in court, such as a TIFF or a PDF, using specialized software or tools. These tools allow the user to select the file or the files to be converted and to specify the desired output. As lawyers, as legal professionals, we all know the safety measures that entail converting your Word documents to PDF to ensure that it's not corrupted. TIFF is just the same thing, but for images. Additionally, when it comes to e-evidence, it's important that you don't tamper with the original evidence and just make a copy of it, so that you're not told that it was tampered with and it's not admissible in court. Let's go to the handling of digital evidence. This needs to be handled in a manner that preserves its integrity to ensure that it can be used as reliable and credible evidence in court. And this afternoon I'm going to talk about two methods. One are checksums, which is a purple chart, and the other are hash sums, which is the green chart. Sounds complicated? Very simple. Basically, a checksum is a unique digital signature or code that's generated from the contents of the file. If you see on that image, we've got the word Fox, and then we've got some digits associated with it. When you get to the second line, even if the word Fox is there are other words, but there's a different signature. So when it comes to check the authenticity and integrity of your digital evidence, if the two checksums match, it means the file has not been tampered with and its integrity is preserved. And a similar thing applies with the hash sums. Let's go to the next slide on preserving digital evidence. E-evidence should be preserved in a way that it ensures it will not be lost or damaged in order to maintain its integrity and credibility. And especially because in e-evidence, sometimes you're talking about a flash drive. It's something that can be easily picked up. It's not like huge court files you're walking out with. So one way to preserve e-evidence is to make multiple copies and store them in different locations. But when you're making copies of this e-evidence, it's important to use software or tools to create an exact replica of the original file rather than modifying the original one. And one way we do this in cybersecurity is using forensic software and or hardware writer blockers. And on the screen, just for you to understand, are various forms of hardware write blockers. And these instruments will create, it's like your photocopying machine. They will make an exact copy of the digital evidence. And once you've done that, you can store this evidence on various media forms, you know, from your hard drives to your CDs to your UBSs, and then store them in different locations. Remember, don't keep all your eggs in one basket, because this e-evidence is very easy for somebody to walk off and walk away with it. Make sure it's in a fireproof safe or an off-site storage facility. Additionally, it's important to keep in mind that e-evidence can be vulnerable to data corruption or loss due to environmental factors such as temperature, humidity, or electronic magnetic interference. We've heard cases in the past of where physical court papers were allegedly eaten by rats and they could not be adduced in court. You don't want somebody to come with a strong magnet and delete all your e-evidence. So these are precautions that you need to take to ensure that it becomes admissible in court. When it comes to adducing the digital evidence in court, it needs to be presented in court in a matter that is clear and easy to understand, by providing a clear explanation of the technology used to create and collect the evidence and how it's relevant to the case. And this can be done by hiring an expert witness who will come and, in simplified language, be able to explain it to the court. It's all about simplifying it. When you're amongst peers, talk the jargon. When you're talking to everybody else, simplify it so it's understandable. Using visual aids, like I've used today when I showed you the hard writers. If I had just stood here and said a hard writer, you may not have understood what it is, but a picture speaks more than 1,000 words. Demonstrating how the evidence was obtained, establishing the authenticity and the integrity of the e-evidence, and showing the relevance of the e-evidence to the case. If you follow these steps, then for sure you're going to have your evidence accepted and be able to have an effective prosecution, because cybercrime is really, really problematic to prosecute. The number of successful prosecutions are still very low because attribution in cyberspace is a bane. So when you've attributed, you need to make sure that your evidence is in such a manner that you're able to ensure you get a successful prosecution. So how do you secure the chain of custody for this digital evidence once you've collected it? It's similar to what you do with regular evidence, but in cybersecurity, we use software. And this includes minimizing the number of people handling the evidence. And here I'm going to insist that anybody who's handling your e-evidence has to be qualified and trained, because it's not the same way you handle your regular evidence. Because if they do something that's erroneous, that will make that evidence automatically inadmissible in court. Then there's the tracking and the recording of the movement of the evidence, keeping your audit trails and your records, which you do with regular evidence. Maintaining the integrity of the evidence. And this can be done using forensic software like the hardware write blockers that I spoke about earlier, which create an exact replica without actually affecting the original evidence. You need to use secure methods of transmitting and storing this evidence. And one of these secure methods is encryption. And for those of you who don't understand encryption, I'm sure many of you have WhatsApp on your phones. And on WhatsApp, it says end-to-end encrypted, which basically means if I was to send you a message from my device to your device, in cyberspace, it turns into something incomprehensible, gibberish. The tech guys will get mad with me for using the word gibberish. But when it hits your device, the decryption code now allows it to be converted to either the image, or the audio, or the text message that I had sent you. So it's important to use encryption. And we need to be proactive because quantum computing is going to become a reality in the next decade. Quantum computing is going to be able to delete, almost make obsolete most of our current encryption methods. So even as we're planning for prosecuting cybercrimes, let's be proactive. Let's start looking at ways to secure data in a quantum world because it's a reality that's not too far off. The final thing I'm going to talk about this as regards chain of custody is keeping a detailed record of the entire process. And this is similar to what you do with your regular evidence. When it comes to the authentication of digital evidence, authenticating e-evidence is crucial to establish its relevance, reliability, integrity, and its admissibility in court. The most common ways to authenticate e-evidence include metadata, and I love using the analogy of the iceberg you have on your screen. When you see an iceberg, it just has a small tip at the top, but at the bottom, it's huge, it's colossal. That's exactly what metadata is. Data is what you have at the top. Metadata refers to information embedded in the file that describes its characteristics, such as the data was created, the author, and the software used to create it. And so that's the data you need to be able to effectively prosecute. Hash values we've covered. Digital signatures, they use encryption and the hashing technology, so they make your signatures, your digital signatures secure, and so enhance the integrity of the document signed. Timestamps. Timestamps are basically a digital record of anything you do online. The tech experts will be able to go and see at this hour, this second, you did that. That helps you when you're trying to follow your evidence trail. File carving, which I mentioned earlier, is actually, there's an image on the screen where you can see one image has all the data then one has a space where there's a gap. File carving is a technique used to extract files from a disk or a memory image to find deleted, hidden, or corrupted files. Because these cyber criminals, if they know you're tracing them, will try to delete their information. And then you need to also practice forensically sound preservation. And so this needs to be done using forensic software, like the hardware write blockers, to create an exact replica. I will keep on repeating, please do not tamper with the original evidence the same way you don't tamper with regular evidence. And finally, I can conclude without talking about legal compliance for digital evidence. It's important to comply with the rules of evidence and the specific laws and regulations related to the admissibility of e-evidence in court, which raises the question, do our current evidence acts or our procedure laws adequately cover the nuances of cyberspace? Do we need to review them? Because in cyberspace, attribution is a bane. Information disappears in the blink of an eye. Are we prepared for that? Do we need to look at creating a cybersecurity information sharing act, kind of like how in the world of counterterrorism, another hat I wear, we have the terrorist acts, where we're able to move and act and get orders. Because right now we're sitting in this room, there could be a kid with a keypad sitting on the other end of the world in the Bahamas or somewhere who is hacking our systems and we're not aware. As we get that information, we need to be able to move fast and not wait for the courts to open to get orders to be able to track this. So these are conversations, and I challenge you, the great minds, legal minds of Africa, to let's engage further in these conversations and see what we can do. Thank you for your attention, and happy to help you with any cybersecurity consultancies. I hope I didn't do that wrong.
Thank you so much.
Thank you.
Thank you so much. So you can see that we have expertise in Africa. We don't need to look very far. And just half a minute of a recap of what she has just given us, the principles of electronic evidence. As prosecutors, we have been armed. She has talked about the data integrity is key, audit trail, which means everything that you do can be audited, that another expert can come and follow the same process and come to the same conclusion. Specialist support. You need experts in this field. So we should think outside the box as prosecutors, that what kind of expert would you need to even analyze your evidence, to even be a witness in court. Then appropriate training is key across board for the prosecutors, for the investigators, even for judicial officers. Then of course legality, the last one, legality. Processes must be secure, they must be trusted, they must be authentic. So thank you so much for your presentation. I just want, before I come to the prosecutors, let's finish up with the experts. Mr. Osunga, can you please come and use your 7.5 minutes and tell us more? Thank you so much.
Thank you very much. My name is Alex Osunga. I'm the technical lead at iLab Africa, running the Security Operations Center. A lot has been presented about digital forensics, and for me, I would start with first responders, because through the process of digital forensics investigations, there is a team of experts, including the legal advisors, that is the prosecutors. In digital forensics, first responders play a very key role in ensuring that the evidence that we collect, or the evidence that ends up in a forensic lab for analysis, is secured. And therefore, because most of the time you will find that in these cases, the first responders are the police officers, or any other person that is on site, that is first to arrive at on site. That is, if where the crime was committed at a physical location, but always there's a physical location from where the criminals work from. And therefore, the first responders need to have basic skills in ensuring that they secure the evidence because they're the first people to get on site. So always make sure that as you work in a team collecting evidence, always make sure in your team, or if it's a police officer, there's someone who can secure that evidence. Number two would be the process of collecting that evidence at the crime scene. Do we have, for instance, as prosecutors, do you know the right questions that you need to ask at the crime scene? From the collection to the analysis to the acquisition, analysis, and reporting. And therefore, you need to work hand in hand with the technical team that is carrying out the investigations to be able to know the right questions to ask at the crime scene. How is the collection going to be done, or the seizure of systems or devices that have been used in committing the crime. The other bit will be on reporting. Sometimes these reports are written by the technical people, and sometimes they might not be easy to understand. And therefore, as a prosecutor working with the experts, you need to ensure that the report is written in a language that the judicial team is able to understand, because if it's complicated, then they will not be able to understand when it's presented before a court of law. Sorry. The other bit that I also wanted to talk about, because we are talking about the transnational crimes and how to collect that evidence. There's one bit that is called social media intelligence. And sometimes some of these crimes are committed on the social platforms that we have, from Facebook, Twitter, blogs, and so on and so forth. More so, the human trafficking are committed mostly on social media platforms. And therefore, we need a team that is able to understand SOCMINT. We call it SOCMINT, or social media intelligence, because that is where we can gather information about the perpetrators of these crimes. The other bit is also dark web, where we have a lot of information that is encrypted, anonymous people using pseudonyms to commit a crime. So dark web is also another platform where people commit a lot of crime: drug trafficking, hiring hitmen, human trafficking. All these things take place in the dark web. And therefore, as investigators or as prosecutors, you also need to have skills to know what really happens in the dark web. How can investigations be carried out for crimes that have been committed in the dark web? Then, back to digital evidence, there's something called order of volatility. Because sometimes she talked about integrity, ensuring integrity of the data, or because of the data that we collect. She also talked about this data, electronic evidence, is volatile. It can be lost anytime. And therefore, there's something called order of volatility. Order of volatility is about when you get to the crime scene, or when you seize devices at the crime scene, you need to know which data you need to collect first before you leave the crime scene. Because there's data that is more volatile. Data can be lost anytime that power is switched off, or when the device is disconnected from a power source. So when you're with the experts, ask them about order of volatility. Which one are they going to start with? Is it the RAM, random access memory data from the system, that if you switch the device off, then you're not going to collect that data. It's lost at that particular point. So they need to know that there's order of volatility that says the least, from the most volatile to the least volatile. The least volatile is data that is stored in external storage devices like flash disks. There's also the hard disk that is stores least volatile data. I think that's it. I still have 2 minutes. Okay. Yes, so let me go back. I thought my time was up. Let me go back to this order of volatility because it's always very important whenever we are at the crime scene. So the first thing that you need to do when you arrive at the crime scene is to check. Let's say we have different devices from desktops, from mobile phones, and so on and so forth. And therefore, if it's a desktop machine that is on at the crime scene, you don't switch it off first, but you need to make sure that if the browser is opened, if there is any other system that is running in that system, you need to have tools that can enable you to collect the volatile data that can be easily lost during the process of investigation. The other thing would be on transportation of electronic evidence from the crime scene. Most of the time, data is lost in between from where the crime was committed to the forensic lab where analysis is going to take place. We need to package the devices that we've collected from the crime scene well, so that we make sure that we don't lose data. Things like mobile phones, we need to put them in Faraday bags to ensure that they're not still connected to the network. Someone can easily switch them off if they're still connected to the network. And then now, when we get to the forensic lab, where we are going to do the acquisition, the preservation, and analysis of this evidence. At this point of acquisition, we need to make sure that we have the right experts. Not everyone is expert in everything. I might be an expert in analyzing Windows machines. Someone else can be an expert in analyzing Apple or Mac OS machines. Someone can be an expert in Android. So we have to make sure that analysis or acquisition of data is done by an expert for that particular device. They have to know, because if I'm an expert in Windows, I know exactly where to find the artifacts. But if I'm not, then in as much as we are going to procure tools that these people are going to use, the tool is as good as the person who is using that tool. So they need to have the right skills and the right tools to acquire data or evidence from those systems. And then during the presentations, the presenter mentioned about preservation, how we preserve evidence. Within the forensic lab, we need to have the right blockers. We need to have evidence lockers where we can store our evidence to make sure that it's not tampered with or it's not interfered with. And then finally is the analysis bit, where from the data that we have acquired from the devices, we need to make inferences, we need to make conclusions so that we give a very comprehensive report to the judicial team. Thank you.
Yes, thank you so much, Mr. Osunga. You've continued the conversation very well. And basically what I have got as a prosecutor is the process of collecting this evidence. You have told us we have to first identify, we have to be intentional about the collection of this evidence, the processing, the analyzing, and then the most important is the reporting language. If you're going to make your report, even the prosecutor doesn't understand, even the judge doesn't understand. For me as a judge, when I don't understand a case, it is easier for me to acquit than to convict. So it is very important when we write our reports, it's written in a language that can be understood by court, because that's the most important. And of course, he has given us the networks, the anonymity. That is where this all crime just eludes us, because of anonymity. Most of the criminals who commit these crimes are hidden in the dark net. So that becomes a challenge for us. In the first session, we were talking about how much we have recovered, almost nothing. I think these are some of the things that we should step up as Africa and get to the net, because that's where all the crimes are being committed now, almost all. And of course, the volatile nature of this kind of evidence. You just don't go in as a prosecutor, investigator, and switch off machines. You have to know which one to switch off and which one not to switch off. So thank you so much, Mr. Osunga. Now we are going to the prosecutors, and we are going to start from my sister, the DPP of Lesotho. She will definitely, yesterday I was learning how to pronounce this, and my daughter had to put for me a video of how to pronounce. I used to pronounce it as Lesotho, but she said it is Lesotho, something like that. Thank you so much. Thank you.
Thank you very much, Madam Chair. And you're not too far from getting the name right. It's called Lesotho. You know, there is O at the end, not Lesotho. Yes. And good afternoon, everyone who's in attendance. And kindly allow me to pass my sincere gratitude to the Director of Public Prosecutions of Kenya and your colleagues for hosting us. Thank you so much. My name is Tlalefang Mutinyane. I'm the Director of Public Prosecutions in Lesotho. So the discussion will focus on the rules governing the admissibility of electronic evidence within the legal framework of Lesotho in particular. The criminal courts on a daily basis are faced with the question of whether electronic evidence presented in criminal proceedings is admissible evidence or not. It may be argued that admissibility centers on the type of electronic evidence, namely documentary or real evidence. The common law governs the admissibility of electronic law. The statutory law is not yet in place, as the bill has not yet been passed in Parliament in Lesotho. So no special rules or evidence govern electronic evidence. The law relating to electronic evidence is hampered by a lack of procedures governing the collection, storage, and presentation of electronic evidence for purposes of criminal proceedings. Only once the latter is addressed, the environment relating to electronic evidence will successfully meet the challenges of this era and fulfill its important role in proving crimes committed within the electronic medium. So years ago, the internet, cyberspace technology, and criminal conduct or acts in cyberspace were regarded as fiction, but they are actual realities of today. Most modern societies function within the physical and electronic mediums. These involve around the issue of technology devices such as computers, iPods, iPad, laptops, mobile phones, etc. Electronic mediums create more opportunities for the commission of crimes such as identity theft, online child pornography, money laundering, etc. When such a crime has been committed, the victim in the subsequent criminal proceedings may wish to rely on the information distributed or stored on electronic devices, such as spreadsheets, emails, text messages. Electronic evidence or data is relevant in proving or disproving a fact or point in question relating to the guilt or innocence of the accused, and as such, the information forms part of the totality of the evidence before the court. This information constitutes or forms part of the electronic evidence, and the rules of law of evidence are applicable thereto in deciding the admissibility. Technology can live up to its billing of making life easier and more efficient for all of us, despite how criminals may employ it. If we effectively use electronic evidence to prosecute those criminals and reduce the opportunities for technology to be used against us. The question is whether the traditional law of evidence, which arises from physical medium, has developed enough or sufficiently to provide for a question of admissibility of electronically recorded and transmitted information. Although one may believe that electronic evidence is trustworthy, reliable, and easily admissible, challenges inherent to electronic evidence face most criminal courts in the electronic age. Lesotho Computer Crimes and Cyber Security Bill 2022. The focus on this discussion will be on the admissibility of electronic evidence from the perspective of Lesotho. It will be assumed that the evidence was lawfully obtained, as evidence lawfully unlawfully obtained will in all probability be inadmissible. Lesotho is lagging in cyber security issues due to a lack of policies and strategies, thereby exposing it to all sorts of cyber crimes. Lesotho has not yet passed Computer Crime and Cyber Security Bill as law, which is hailed as a move towards advancing cybercrime protection. Section 27 of the bill deals with the admissibility of electronic evidence and incorporates reference law dealing with electronic transactions and communications to apply. Part 5 of the bill provides a set of procedural instruments necessary to investigate cybercrime. It also provides for the identification of offenders and protection of the integrity of computer data during an investigation, and contains several inherently unique challenges for law enforcement authorities. The purpose of Part 5 is to improve the national procedural instruments by defining common minimum standards based on best practices within the region as well as international standards. The definition of standards will help national lawmakers to discover possible gaps in domestic procedural laws. Sections 28 to 35 define minimum standards, and therefore do not preclude the creation of more extensive criminalization at the national level. Further, Section 35 introduces new investigation instruments and aims to adapt traditional procedures measures such as in Section 28. All instruments referred to aim at permitting, obtaining, and collecting data for purposes of conducting specific criminal investigations or proceedings. The instruments that are described in Part 5 are to be used in both traditional computer crime investigation and in any investigation that involves computer data and computer systems. Before I conclude, I would refer to the case of S versus Ndeki, 2007, to All South Africa Law Reports, 185 at page 13. It was stated that, finally, in dealing with computer evidence, it must be recognized that computers are not infallible and that the dangers inherent in this type of evidence must be acknowledged and necessary safeguards put in place. What is missing is the law of evidence, detailed procedures that the courts have approved as complying with the general law for collecting evidence, storing it, and presenting it in court. Only when the procedures are in place will the law of electronic evidence be fully effective in Lesotho. And I'm hopeful that in the next 2 months from now, maybe by March, the law will have been passed in Lesotho. I thank you for your attention. Thank you.
Thank you so much, DPP Lesotho. And you said it ends with an O? Lesotho. Okay. Lesotho. Thank you so much. What she has basically told us is just the challenges that we as prosecutors across Africa, maybe even across the globe, face in how we present this evidence in court. And of course, it begs for the question of what do we do next I think there is need for harmonization of laws across the globe so that we can be able to tackle this, because any weakness in any law is actually an entry for criminals to take advantage. Now we go to the next prosecutor, Deputy DPP Kenya. Please take the floor, 7.5 minutes. Thank you.
Good afternoon, and thank you very much. Chair, thank you so much for guiding this discussion right from the beginning. Listening to the experts, now we know what our investigators do before they bring a file to us. Without even going to the presentation, the issue of evidence collection and what needs to be presented in court is something I think most of the African countries have been able to have managed to do so far. On a day-to-day basis, I can be speaking about the Kenyan context. What our brother was presenting, to the effect that we should know where to collect the evidence. This ideally is something which the investigator actually deals with. But there are situations where the prosecutor needs to guide the investigator. And that is something we do from time to time. Ideally, we would want a situation where all cases, especially cases which deal with online exploitation, have a prosecutor on the ground. So thank you so much for bringing that to our attention, and I think we are well guided. I have a special brief to talk about children or juveniles, or children who are within, who either are who are against, who have committed crimes, or children who are victims. So I will have a special brief to talk about transorganized crime, specifically on children. I would request my colleagues to open the presentation. All right, on transnational organized crime, it is notable that online sexual exploitation and abuse of children was ranked as one of the top 10 crime trends perceived. Therefore, when we are talking about organized crime, this is one of the crimes which we need to protect the victims. The children are very vulnerable, a very vulnerable group. So that being noted, we as a country have been so keen on ensuring that we watch crimes that have been committed, especially on the online platform. Children access internet nowadays from the phones, from their parents' iPads. So you are never sure when children are vulnerable. So at this point, we know that the phone is one point of access, and it's one piece of evidence which must be collected from children who have been harmed within the internet space. When we look at the internet space, what kind of offenses are committed against children? You'll notice that most of the offenses that that children get vulnerable and get into are like grooming, online grooming of children. What happens is that the children, having not knowing that the person they are engaging with might actually be an adult, they actually think most of the time these are persons of their age. So children engage. Sometimes they even send very vulnerable photographs of themselves or images of themselves. These photographs are sent out, and the offenders take advantage of the child, and they use these photographs they use these photographs either to extort sexual favors from the children and putting the child in a very vulnerable situation. In fact, most recently we have been seeing children who have even committed suicide because they are unable to manage this kind of crime which has been committed against them. When we are talking about, in the Kenyan context, what kind of laws do we have, or what kind of law do we have? We have, of course, the international law. We are part of the various conventions. One of the conventions being, of course, there are some of the protocols which are under the ANTOC. So those are laws that we rely on as a country to be able to manage these child online offenses. Of course, domestic law, we have the Constitution of Kenya. We have various pieces of legislation. We have the Children's Act, which basically has done as much as possible to ensure that we protect our children from the offenders who are within the online space, or within that space where they are either bullied or at times they are even put in a space where they are even trafficked, or at times they are even killed. So this is the law we have domestically. We have the Children's Act, we have the Sexual Offences Act, the Data Protection Act, and the Computer Misuse and Cybercrime Act, which our experts have alluded to. Of course, technology as an investigative tool has been alluded very clearly, but by our experts, I need not go through that again. But I may need to talk about, child witnesses. How do we handle children who are witnesses? As a country, currently we have what we in some various court stations or counties, we have child-friendly rooms. In that space, we are able to listen to the child who is a witness, understand their mind at that point. How are they ready to attend court? What are we able to do to manage? But we have also mooted a very important way of dealing with the children. Because of their vulnerability, they also forget very quickly. So with the children's or the juvenile justice division, we have actually had a lot of, we even have a concept on how we are going to manage children. For instance, if a child has been harmed or has been, an offense has been committed against them, we are recording this kind of evidence from the child immediately, what we call pre-recorded evidence, so that the child doesn't need to keep on repeating that evidence over and over again. So from where we are sitting, we can say that as a country, children are one of the vulnerable groups that we have gone out of our way to ensure that we protect them. So with that, I can say that children witnesses, their evidence is going to be protected, and we are happy that our experts have spoken to us about it. Thank you very much, and I think we can still engage. Thank you.
Thank you. Thank you so much. That was very key for us, online child sexual exploitation and abuse, which is now a big thing. It is the new focus. Thank you so much, Deputy DPP, for that. Last but not least, we have the last prosecutor, Mohammed, is the chief prosecutor in charge of international cooperation, Egypt. Thank you. You have 7 minutes or less, if you can make it. Thanks.
Thank you, Honorable Prosecutor General Lady Justice Jan, DBB of Uganda. And actually, my position is very hard after this presentation, precious and interesting presentation of my colleagues the experts and prosecutors from the different African prosecution authorities, it make my job difficult to give an interesting presentation. But I try to keep my presentation short as much as I can, and to be able to be in the timeline. Well, I would like to. I think my presentation is ready. As you know, as all of you know, that there is a definition of a digital evidence, which is information that has been extracted from any stored or transmitted or obtained computer devices. I've tried in this presentation to shed the light about the challenges that face the investigator in human trafficking cases when it deals with information technology, or if the crime has been committed on internet. So usually, as all of you know, that the definition of the digital evidence is the electronic information that is having evidential value, either transmitted or extracted or stored in any of the computer devices, networks, or similar sources. But the main challenge that face the prosecutors in investigating the human trafficking cases is the, can you get to the next slide, please? Yes, is the nature of the crime. Usually when we would like to prove that kind of crime, we need to prove that there is an exercised authority over the victim of this crime. And usually that kind of evidence we have to provide, we need to get the communication between the offender or the perpetrator of the crime and the victims of this crime. So this is one of the challenges. Second challenge, the time factor. Usually long periods of the time between the occurrence and reporting of the crime, and in another hand between the reporting of the crime and collecting the data. Usually this data, our time frame, usually may consider to be a challenge for the public prosecutors to gather such kind of evidence. The big data that we found it in the evidence is considered also a challenge to analyze this kind of evidence and to get it. Also, if you would like to have evidence from the foreign jurisdiction, we need to send a mutual legal assistance request, and the usually differences in legal system, as well the long duration, the MLA request process usually you find. So usually those are the main challenges that we face during the investigation of that crime. So I would like to shed the light upon, when I speak about a case study that we had done in the Egyptian Prosecution Office, about how we can overcome such kind of challenges. So first, next slide please. Usually this evidence is found in electronic devices like the computer, flash memory. So usually when we are investigating or we are gathering the evidence, we have to put in my consideration this kind of devices while I'm doing the search for the apartments or even the accused. Also, digital evidence can be found in service providers, also can be found in the applications and the website websites. Usually these electronic applications contain an instruction of directly of how the crime has been committed or how the instruction of the offenders. So this kind of evidence usually found in that area. Next slide. When we obtaining and preserving the digital evidence from the electronic devices, I have to put in my consideration the following. Usually the legal framework, how I can get the evidence, the legal basis to get this evidence, how to seize it and this evidence, and how to be inspected by the investigator, and how to be inspected by the expert. Because sometimes when the investigator enters to examining the evidence or try to make his search, he usually can destroy the electronic evidence. So usually how to do that, to do this issue. And also the preserving the evidence and preserving the evidence, and as you have mentioned, it has been mentioned by my colleagues before about the custody and how we can preserve the evidence until we go to the court. So I can skip the next few slides until we have the slide of the case study, which is much more interesting. We had a case study that we had it in Egypt, where a victim of the crime is the defendant has been monitored. The defendant has monitored the victim's website, a social network profile, and started to get contact with her by chat and start to become friend of her. This defendant is an adult, while she was a child under 18 years old. He started to be pretended to be a child like her age, and started to connect to her as a child and ask her to send his photos. At the second phase of the crime, where the defendant started to use threat defamation, enforcing the victim to engage with him in a video conversation, asked her to appear nude in one of the videos, and then the defendant published those videos on one of the pornographic websites. When the crime came to the prosecution office, we had some evidence founded from the victim testimony, and we find the observation of the video content, and also the police inquiries, which show that the phone number connected. There is a phone number connected to an email, and this email has established this profile on Instagram, and this founded that the number is owned by his father, but the telephone is on the custody of the child. So. Okay. So we started to we drafted MLA request to the foreign country, United States, and we have a very successful thing that we have preserved the evidence in the pornographic websites and the social networks by preserving it by giving a preservation order to these websites to not to destroy the evidence and to keep it until we send MLA request to United States. And also we use the informal communication where we'll be able to preserve the evidence and collect the evidence afterwards. So we had this successful story, and we can lesson learned from that case that you can use the international cooperation, you can use the informal way, and also you can use the preservation orders that you can send it to the social networks or websites to preserve the evidence until you send official MLA request to the other country. And this is one of the interesting things that is appeared as in front of us as a prosecutor in that kind of cases. And as you may notice that this preservation order assisted us in getting a formal evidence from the United States, contain all the evidence of the case, where we has a successful prosecution against this defendant, and then we have enough evidence showing that the crime has been committed, and that the social network, that the websites, pornographic websites, the videos that has been uploaded there attributed to the defendant, because this was a challenge in front of us. And also we provide an evidence showing that the accounts on the social media network that has been used to communicate with the defendant is attributed to the defendant. I hope, I know it was a little bit hurry and presentation, and but I'll thank you, and if you have any questions, I will be delighted to answer it afterwards, and thank you for giving me the chance to present. Thank you so much.
Thank you so much, Mohammed. Thank you. That just brings us to a continuation of the same prosecution challenges that we face, and especially how do we handle child witnesses. So Mohammed has taken us very well on that, a continuation from my sister's presentation. Now we are done. We are in plenary. We have about 15 minutes for plenary because time was eaten up. It was supposed to be 30 minutes, but now we have 15. If you have a comment, if you have a question, the floor is open. Yes, we have a hand there. At the back there. And then second we shall have from Shamini, yes. Please, let's make them short and to the point.
Thank you. Good afternoon, and I would like to commend the various presenters for those very thought-provoking presentations. My name is Patrick Kiage. I am a judge of the Court of Appeal in Kenya, and I am a former prosecutor in the office of the ODPP. I would like to just weigh in on this discussion and perhaps suggest a thing or two. One, I agree entirely on the need for expert testimony to be simplified. I think there's a poet who said, simplify, simplify, simplify. Truth is, a lot of what we see, even this afternoon, could very easily seem like Greek or worse, perhaps voodoo or witchcraft to a judicial officer. So until and unless it is possible for the expert witness to actually break it down, tell it to me as if I were a 2-year-old, so that I can understand it. Because truth of the matter is, judges are human beings, and there is a human inclination to reject that which you don't understand. So it's important that you break it down so that we get to understand. And how do we, other than making it simple, how else do we go about this? I want to suggest that there is need for training. There is need for training, as in serious training. And this, I think, could be done in a collaborative kind of way. I don't see that there's anything that is doctrinally wrong with having magistrates, investigators, and prosecutors, all players in the justice system, being able to be taken through this kind of very technical trainings. So, because unless we understand it, we can't get it right. And I suggest that it is important that law enforcement officers should be as good, if not better, than the bad guys in dealing with issues technology. And finally, I know that there is need for legislation and rules and regulations to be in place, but we do know for a fact that Parliament can take a while, not just the Kenyan Parliament, but I'm sure that's your experience as well in your various countries. And if we wait until the law is in place, then we might be, long distances behind the bad guys. I suggest that once we have some knowledge of technology, it is important that we try to be a bit more innovative. We try to think outside of the box and try to bring the judges and magistrates to a place where they can understand, follow through, and get convictions where it is possible to do that. As a prosecutor, I'm about to finish. Many years ago, I remember I tried in 07 to have a magistrate admit evidence from a witness who could not come to Kenya by way of video link. I did some serious research and so on, and when I went before that magistrate, the magistrate was better persuaded by the defense lawyer, who said that what I was suggesting is something that razzmatazz, as he called it, is something that I should spare for my university students and not in court. It was rejected by the magistrate, but we plowed on. The learned judge, when we went on appeal, for revision actually, the judge agreed with us, and in our country now, this is commonplace. So it is possible to actually have the courage to move on and strike new ground, even where the law may not be exactly in our favor in black and white. Thank you.
Thank you so much, Justice of the Court of Appeal. I don't know whether those were rulings already. He asked the questions and gave the suggestions. Thank you so much. Can we have Shamini, please?
Thank you. I'm Shamini Jayanathan. I'm a consultant with UNODC. The volume of material that can be generated from a telephone or a computer can be vast and overwhelming. And when it comes to online sexual exploitation, particularly of children, but even adults, it does raise questions of disclosure of that material as part of the prosecution case. I've seen in some jurisdictions those very images being disclosed to the defense, which basically means further offenses effectively being committed and the victim is being re-victimized by those who are seeking to protect that victim, unwittingly in nearly all cases that I've observed. And so really a little bit like Judge Kiagi, this is a recommendation more than anything, that it is vital that relevant policy on the issue of disclosure, not only of evidence that you're going to rely on, but all of the unused material which, if you were to perhaps download the contents of my laptop, it might fill half this room. It is important that we get ahead of the curve before the law and perhaps lawmakers step in and place an obligation on your services that will be so overwhelming that you won't be able to comply. So there are two aspects. There's a disclosure of the evidence, and then there's disclosure of unused material, which is all of the other stuff that's been generated, which may actually undermine your case or assist the defense. And as prosecution authorities, we have an obligation to consider disclosure under the African Charter on Human Rights, Section N of their 2003 guidance and principles. So again, a little bit like Patrick Kiagi, I'm just suggesting that we need to get ahead of the curve if you haven't already. Thank you.
Thank you, Shamini. Do we have another intervention? Right. Okay. There, and then it was the first to put up his hand, and then we shall take the last one back here.
Merci, Madame le modérateur de la séance. Je réponds au nom de Kubuayo Isaac. Je suis le substitut du procureur général de la République du Burundi. Je m'en tiens au cours de cette récente présentation sur les points du cadre légal de l'administration de la preuve électronique. Ce qui me tient à cœur, c'est que nos différents systèmes légaux de procédure ne sont pas équipés des mêmes voies pour l'administration, bon, la collecte, l'administration et l'admissibilité de la preuve électronique devant les instances judiciaires. Ce que aussi je peux noter, c'est que il y a des législations qui sont évoluées sur cet aspect-là. Le présent cadre de l'association des procureurs africains pourrait être un bon cadre pour contribuer à l'harmonisation ou à l'unification de certaines règles de procédure par la mise en place, par la proposition des lois types à des pays qui en ont besoin pour améliorer leur cadre légal de procédure, puisque après tout, au regard de l'évolution technologique, on ne doit faire autrement que d'ouvrir nos systèmes de procédure pour accueillir ces voies de présentation des preuves électroniques. Donc, le cadre de l'association des procureurs africains ou d'autres cadres associatifs des institutions de poursuite sont des bons cadres pour promouvoir l'amélioration de nos systèmes légaux en vue d'accéder à la mise en œuvre de l'admission ou de la collecte et de la présentation des preuves électroniques dans nos procédures. Merci.
Thank you so much. We have the next one, and then we have the last one here.
Bonsoir. On m'appelle Thomas Maoyondassi. Je suis procureur général au Bénin. Je voudrais remercier les différents présentateurs d'abord. J'ai constaté lors de nos échanges de ce jour, déjà de cet après-midi, que les pays anglophones sont on ne peut plus avancer dans le domaine de la lutte contre la criminalité transnationale organisée. En témoigne le nombre de participants ici des pays anglophones. Ce que je voudrais demander, est-ce qu'il y a une possibilité, quand nous parlons de collaboration, est-ce qu'il y a une possibilité de pouvoir organiser les échanges entre, d'une part, les pays anglophones et les pays francophones? Est-ce qu'il serait possible de mettre en place des bases de données dans les deux langues, bien évidemment, anglais et français, pour permettre aux procureurs généraux et toutes les autres personnes qui participent à la lutte contre la criminalité transnationale organisée, l'abus sexuel des enfants et autres, le trafic des enfants et autres, pour qu'ils puissent échanger de façon un peu plus rapide. Voilà la question que je voudrais poser. Merci.
Thank you so much. We have the last one. Yes.
Thank you, Chair. I'm George Thomas Thatchett, Head of the Prosecution Division at the Attorney General's Chamber in the Republic of Seychelles. I just want to add something to what the UN Representative Shamini Jayanathan was referring to about disclosure, especially involving online child sexual cases. So often the prosecution authorities are obliged to do a full disclosure of the evidence gathered to the accused. And that involves, again, we are putting the vulnerable children or the evidence involving the vulnerable children at the hands of the accused perpetrator. So how can we prevent the further misuse of these materials at the hands of the accused? Sorry to say, even in the hands of the defense lawyer or from the prosecution side. Or what happens to these disclosed evidence after the completion of the trial? So, because of the constitutional issue of right to have a fair hearing or the full disclosure of the accused. So this may be a consideration for this forum to think about. Thank you.
Thank you so much. I will now give time to our experts and presenters to answer the questions or make comments to what the Justice of the Court of Appeal said of training, joint training, and sort of forecasting crimes as well. Shamini's concern, harmonization of laws from my brother there, and then the English-French forum, and of course the last intervention. So I will just start with you. You answer the question, and then you give your parting shots in less than 1 minute.
I love what Justice Kiagi said about capacity building, because that is actual and factual. From law enforcement, the judicial cycle needs capacity building. The law enforcement officers across Africa need to be trained on how to collect digital evidence. They need to be aware of digital wallets, which they extract the evidence and then move it offline into something we call cold storage, which is a digital wallet not connected to the internet. Then the prosecutors need to be trained on basic terminology. You may not go into the deep nuances of what the technology is, but when you're going into court, you need to say, was network forensics done? Was a checksum carried out? The judges need to have that capacity. And so capacity building is necessary. I'm actually working on a program with a local university, and hopefully by the end of this quarter, we'll be able to announce it so that we can give the judicial sector cybersecurity capacity building. The other thing I'm going to raise now as a parting shot before so the rest can answer is I'm going to challenge you African legal minds. We have two major conventions on cybercrime and cybersecurity. There's the AU Malibu Convention, and there's a Budapest Convention on cybercrime. Only 4 African nations have signed them. How are we going to get assistance? We're talking about mutual legal assistance. We're talking about cooperation, strengthening cooperation. If we're not even signing the 2 most important conventions which will assist this mutual legal cooperation, how are we going to combat cybercrime? The other one, and this also goes out to the rest of Africa, only 12 African nations have cybersecurity strategies or cybersecurity incident response plans. And some of them have developed them and put them on a shelf. How can you secure your nation's cyberspace? How can you prosecute these crimes if you haven't even assessed or strategized for these risks? wondering how to start, the ITU, the International Telecom Union, has a toolkit that you can use. So go back, develop your strategies, because that will also help the prosecutors when the governments have a strategy on cybersecurity and cybercrime to effectively prosecute.
Thank you so much. And any other person?
Thank you so much, Madam Chair. I'll start with the Honorable Justice, and I agree totally that training is fundamental for us to have a successful prosecution. And all the players must be on board, meaning starting with the investigators, prosecutors, judges, and magistrates. We should all understand how the cyber law gets into play. And without that knowledge, we cannot be able to get justice. And thank you so much, and I hope that will be put, or it has already been written down as a recommendation. Further, my fellow DPP from Benini, you talked about the possibility to organize space for sharing. In my humble opinion, I think it's at platforms like this that we are able to sit, discuss, and make decisions, and where we can make MLAs which can make our work possible for us to be able to curb cybercrime against in all the corners of the earth, across board, in our jurisdictions, everywhere. It doesn't matter whether we are English speaking or French speaking, but we can be able to achieve that. That's why we have meetings like this. Thank you so much.
Any other intervention?
Thank you very much. On Justice Kiagi's intervention, I totally agree. And I thought he talked about being innovative when we want to have some pieces of evidence presented in court. And of course, when listening to our experts, we noted that there are things we have to look at. We are doing as much as possible as prosecutors to be innovative so that we are able to work for the victims themselves. As I had already indicated, the Office of the DPP has a situation where we record statements, particularly of children who are very vulnerable and are likely to forget some of the evidence that they have alluded to. Of course, on the issue of disclosure, I do agree with Shamini. On having legal frameworks or harmonization of the legal frameworks between the Francophone and Anglophone countries, I think this is the right platform, and I'm sure our team leaders are listening to this. I think that is okay for me. That is a plus. That was a very good suggestion. So that is my take. Thank you very much.
Okay, thank you. I'll just go to the issue of expert witness. Yes, the expert witness should be able to break down into detail on how the investigation was carried out, what the technical terms mean to the court. That is very important, and that's why we have expert witness coming to the court to give these explanations. And then the other bit that my colleagues here have talked about, and I still want to emphasize on, is the bit of training. In cybersecurity, we say that you cannot know how to defend if you cannot break into the system. If you know how to defend, then probably you know how to break into the system. Same to the prosecutors. You cannot, present a case that you don't understand the terms that you're talking about. So it's very important to take these trainings in digital forensics, not going into the technical details, but just what can enable you to present a case in a court of law. And then the other bit of, I think there was information sharing, which I know is always a big problem, more so in financial crimes when banks are hit left, right, and center. It is a challenge because of the reputational damage that everyone fears. But yes, it's always good to share this information. And we always say in security that the information that is shared is not the details about the organization that has been hit or whoever the organization that has been hit, but it's the details of the attack that has happened that will help other organizations to take up these cases. So I think that's it from me, but my parting shot would be on the bit of still training. Please make sure that you take these trainings seriously so that you equip yourself very well to be able to present this case. I'll give you an example. I don't know whether I'm allowed to mention, but sometime in August in Kenya, if you watched the presidential election petition from everywhere, you could see that what was being presented, there are people who didn't really know what they were presenting to the court. And I will give an example of the images that were being presented. If you're a forensic expert, you could tell that someone took a piece of envelope, put it on top of something, and took a picture and presented it to a court of law. So if you're a prosecutor and understands how image analysis is done, then you are able to defend such kind of, or give explanation of such kind of things. So it's always very important to have, take these trainings. Thank you.
Thank you. Maybe I have a few remarks and comments regarding what have been said about the questions that have been raised. I cannot agree more about the importance of building the capacities, which is a great step that can raising the awareness of the public prosecutor of how to deal with the evidence, because also in some prosecution offices their authorities not only to prosecute in front of the court but also investigate, like the prosecution offices in many of the African countries like Egypt and other countries. They have the two authorities. So to give them training, to give them building capacities program, to know how to deal, how to coordinate with the experts. Also one of the important aspects of how to deal with the technical expert that is dealing to analyze and examine the evidence is really an important issue. And also what to be requested from the technical evidence, from the technical expert, and what you want to need from this evidence. Another also important comment that in course of asking or a technical expert to examine an evidence, you have to give him a summary about the facts of the case, to get him a knowledge, to get him on board of what you are investigating, because this is really an important, because he can come up with another evidence or another information will assist in proving your crime. And another comment regarding the international cooperation. Yes, maybe we don't have, maybe in Africa, we don't have a lot of we don't have an international judicial cooperation convention, but we can cooperate with others according to the principle of reciprocity. One of the famous principles that we can use to a request from another country and cooperation and to provide an evidence of it. And platforms like that expand our networks. We can now have our focal points from different prosecution offices. We can get use of this kind of hubs and networks to facilitate our job in that time. And also we cannot we cannot only build on the formal request. We have to encourage the informal procedures. I mean, you have to communicate through informally through the colleagues from different countries that can assist in executing the request as quick as possible. I think this is from my side. I thank you for your listening and for your questions and comments. Thank you, sir.
Thank you so much. Give it up for our experts and our seasoned prosecutors. So you can see that we have the human resource. We have no excuse. And very briefly from the proposed recommendation as they made their presentation and parting shots I came up with this. Is it possible for Africa to come up with its uniform standards tailored to the unique circumstances of Africa? And another recommended practice, review of the various legislations governing electronic evidence and harmonizing it across Africa. That's from the presenters. Think of a mutual recognition of orders across Africa so that there is no uncoordinated movement of orders. The fourth one, propose policies, guidelines, and operating procedures for investigators, prosecutors, and judicial officers. Number 5, extensive continuous training. That has been said by almost everyone. Number 6, information sharing without barriers. No language barrier, whether you're speaking English, French, Portuguese, there should be no barriers. We should collapse all those barriers. And lastly, localize existing international standards. Those are some of the proposed recommendations, recommended practices that I picked as the eminent prosecutors and our experts gave their presentations. I would like to take this opportunity. We've come to the end of this session. I'm so sorry we overshot. I tried so hard, but it was so difficult. Prosecutors love to talk. I want to take this opportunity to thank our hosts, your wonderful, wonderful hosts. And you have set the bar so high. I am so shy to welcome you to Uganda next month, but I'll try my best. And I want to thank Aji in particular for bringing us 2 presidents in less than 2 years. And that is how high this conference has been rated. So I thank you so much. Thank you for your hospitality. Thank you, Kenya. Thank you.
Hello, another round of applause for our moderator. Thank you so much. Sorry for bearing with us. This afternoon we are adult learners and sometimes we get tired quickly, but the day is over and the sessions are over. However, I have 3 housekeeping announcements to make. The first one is that there will be a meeting of the Executive Committee of the African Prosecutors Association, which comprises of